SJC-13206, Malikai Nicholas Taylor v. Commonwealth.
Okay, Attorney Celli.
Good morning, Your Honors. May it please the court, Melissa Allen Celli on behalf of the juvenile defendant Malikai Nicholas Taylor. Also with me on the live stream are attorneys Jason Benzaken and Moira Berry. This case, simply put, is about a Superior Court judge's discretion in matters of pretrial detention. It is not about the jurisdiction of a juvenile court, nor is it about the jurisdiction of a superior court. A Superior Court judge is in the best position to determine whether a juvenile defendant should remain in the custody of the Department of Youth Services after his 18th birthday, or whether that juvenile defendant should be transferred to the custody of the Sheriff's Department. And where the juvenile defendant, like Mr. Nicholas Taylor in this case, is charged with both murder and non-murder offense, no statute nor any of the cases interpreting the juvenile code precludes the Superior Court from doing just that. The applicable statute here is General Law, Chapter 119, Section 68. And Section 68 contains two paragraphs that are really, they can't be reconciled with one another. And the first paragraph of in a situation like this, where a juvenile is charged with both murder and a non-murder charge. Under the first paragraph of Section 68, on the non-murder charge, the statute reads that the court shall commit the child to DYS. But under the last paragraph on the murder charge, the statute reads that the court shall commit the child to the Sheriff's Department. And we know that the language in the last paragraph, a person charged with murder in the first or second degree, does not mean every single juvenile charged with murder in the first or second degree is automatically held by the sheriff pretrial. For instance, right now, we have a situation where if a child has a pending delinquency charge or a youthful offender charge in the juvenile court, the juvenile is frequently held for the duration of the pending juvenile court case in DYS custody while released on recognizance in the murder charge in Superior Court. This is something that happens right now. The defendant's interpretation of this statute, allowing a Superior Court judge the discretion to hold the juvenile on either the murder charge or the non-murder charge, really, it maintains the status quo as things were prior to the court's decision in Soto. Prior to Soto, when the statute was enacted, we didn't have this problem of the two separate paragraphs coming into conflict because
respectfully, I don't understand what you just said. It's the status quo before the SJC did something in Soto?
I'm sorry. At the time, I'm sorry for the confusing language. The status as it was at the time that the statute was enacted.
But what you're asking, and with all due respect to what the Superior Court judge wants to do, you're asking the court to just ignore the fact that the person's been charged with murder. I mean, the statutes involved in DYS are supposed to protect not only the juvenile, but all the other people that are held in the DYS facility, right? Because we don't want people that are adults charged with murder with kids or other kids.
That's right. That's right. But there are a few moving pieces to that question. The first is that to read the paragraph, I believe you're looking at Section 68, the last paragraph, you would have to read that in isolation or insert additional language referring to the entire case. As it stands right now, there are two different paragraphs that would apply differently and require different outcomes in that same statute. So reading the statute as a whole, it's not that the court is ignoring that the child is charged with murder. It's that the court is in the best position to determine whether this particular child, given these particular circumstances, is better served pre-trial, by the way, before any adjudication of guilt, before we know whether this child will ultimately be treated as an adult or as a juvenile is in the best position to determine whether that child should stay in the juvenile court, in the Department of Youth Services, or to carry on. And the second
but Ms. Radin's interpretation was an attempt to be faithful to the statute that protects the other kids, correct?
So yes, I think that was her intention. However, I don't think that is a fair reading of the Juvenile Justice and Delinquency Protection Act. The JJDPA has really puts it onto the state court, the state legislature and court, to determine who is and who is not an adult inmate for purposes of that statute. The question here is, if a superior court judge is a court of competent jurisdiction, which can place a juvenile in DYS detention, then that juvenile is no longer an adult inmate under the JJDPA.
How do you get beyond the Soto language?
Which language specifically are you referring to?
That the court shall be treated as an adult for all purposes, or whatever that language.
There are a lot of responses to that. First, that language came directly out of the concurrence in Walls Act, the Lenk concurrence in Walls Act. So I think it's instructive to look back at what was happening at the time that the language was coined in Walls Act. At the outset, this court's decision in Soto, a court's decision about a rule of judicial economy, and by the way, the Conception case makes it clear that the statute being interpreted in Soto, Section 74, not Section 68, which is at issue here. Section 74 is solely about judicial economy. Conception made that abundantly clear. A court's decision about a rule of judicial economy does not change the underlying fundamental rights of the juvenile defendant. And let's look back at what was happening in Walls Act at the time that Justice Lenk penned that phrase. In the Walls Act decision, in the Walls Act case, there was only a murder charge at issue. We weren't looking at two different charges. So we were just looking at the murder charge at that time. And moreover, at the time that Walls Act was penned, it was pre-Diachenko, just post-Miller, pre-Diachenko. So at that time, a juvenile who was indicted on a murder charge, yes, was treated as an adult for the most part. The only sliver of additional protection that the juvenile got was that life sentence without possibility of parole at that point was already unconstitutional. But at that time, when we were talking just about the murder charge, yes, that was true. But now that we know that that's not true. And in fact, the Soto decision makes clear that that is not true. Because if this child goes forward, at the time that we're discussing in the pretrial phase, the child is really in a liminal phase. We don't know whether he will be an adult for all purposes or not. And as the Soto decision says, and by the way, the statute 11972B makes perfectly clear, if the child is ultimately acquitted of murder and convicted only of a non-murder offense or a lesser included offense, that child gets all of the protections back at sentencing. That child is sentenced under 11958 as a child. So at the so we know that the child is not in fact treated as an adult in all respects. And that language, when Justice Lenk penned it, was, in my reading, intended to give a lay of the statutory land at the time, not to pronounce a new rule of law. It was observing what was happening. It wasn't intended to take away juveniles' rights. And I do see that my time is running out here. But at the time of that case, it was in fact much more like the child. Oh, and by the way, also the Walls Act decision itself shows us that juveniles are not treated like adults in all respects. They are provided additional protections, even if we're just talking about the murder charge. And here, what I want to really bring home is that the Superior Court is the one that's in the best position to determine whether it thinks that ultimately this child will end up in a DYS facility. And the last thing that we want is for a child to go to adult lockup and then back to DYS, which is a possibility under any other interpretation. And I see my time is up.
Thank you very much.
Thank you.
Attorney McLaughlin.
Good morning. May it please the court, Assistant District Attorney Laura McLaughlin. Where the legislature explicitly and clearly intended for juveniles charged with murder to be treated as adults for the totality of their criminal conduct, the 18-year-old defendant must remain in the custody of the sheriff and be detained pending trial in a house of correction. Mr. Nicholas Taylor is not a child. He is an 18, almost 19-year-old criminal defendant who has been charged with murder. The offenses have been properly joined. It's notable that the defendant has not challenged joinder as improper, and it should be particularly noted that the armed assault with the intent to rob occurred within seconds prior to the murder. The offenses are very closely related and pursuant to SOTA were properly joined, and both offenses are proceeding in Norfolk Superior Court. Looking at Chapter 119, Section 68, the legislature specifically divested DYS of authority over defendants charged with murder, stating that they shall be committed by the Superior Court to custody of the sheriff. At all times, this defendant has been held in the custody of the Norfolk Sheriff. The defendant was only placed in DYS initially prior to turning 18 as a courtesy to the Sheriff's Department because there is no House of Corrections in Massachusetts equipped with maintaining separate sight and sound separation of juveniles from adult inmates as required by federal statutes. Upon turning 18, the defendant was to be transferred to the House of Corrections as separate sight and sound separation.
Attorney McLaughlin, why wouldn't the Superior Court judge have the discretion to set bail on the juvenile matter and have the person be held in pretrial? In DYS custody pretrial. Isn't that an option?
No, because the charged murder offense commits them to the custody of the sheriff.
But the judge could not set bail on murder. The judge could not set bail on a murder for an adult.
Absolutely, Your Honor. And I would note that the bail judge knew the facts and circumstance of the case, knew the potential penalties the defendant does face, and it was in her judicial discretion to hold the defendant without bail. She could have imposed a cash bail. She did not impose a cash bail. Further, bail is typically set on the criminal case, not on separate indictments. So there's one criminal docket in Norfolk Superior Court. The defendant was directly indicted on both offenses. There was never any transfer proceedings or any juvenile complaints that were commenced in the juvenile court. The Commonwealth.
You see what I'm saying about pretend this person's 35 years old, okay, and they come in charged with murder, and under Vasquez, the judge could say, I know usually people charged with murder are held without bail, but I'm not going to do that. I'm going to set $10,000 bail or whatever. The judge could do that, right?
Yes.
Okay, so then why can't the judge in this instance say, I'm not going to set bail on the murder case. I'm going to put everything on the non-murder charge so they get to DYS pretrial detention? Why is it within the judge's discretion to do that?
Well, I would say the distinction is that there's only one criminal docket. It's not.
Well, I mean, I might disagree with you. I think it might be different practices in different counties, but people set bail on counts on indictments, and usually you set bail on the highest charge, and the other ones just kind of follow along. But there's nothing to preclude a judge from setting bail on one count and not on others.
Well, I would say that would skirt the legislature's intent to treat these individuals as adults for the totality of all of their conduct, and further would run afoul to the bail statute and concerns for public safety, because in those situations, you would be committing or housing someone charged with murder with other juvenile offenders. And I'd call your honor's attention to the amicus letter submitted by DYS that explains that upon turning 18, the defendant is not an adult, that upon turning 18, the defendant is an adult inmate, and continuing to house him in DYS would run afoul to the federal mandates that require sight and sound separation, because now you have an adult inmate with juvenile offenders, and he did commit a very serious offense and was charged with a very serious offense of murder, that the legislature has explicitly intended that when a juvenile commits murder, that they are to be treated as an adult for the totality of those conducts and all criminal offenses that have been properly joined.
Attorney McLaughlin, what would happen if instead of putting the defendant in the DYS, they gave him or her pretrial probation and other conditions with the bail? Would that be okay?
That would be at the discretion of the bail judge. If the bail judge determined that based on the facts and circumstances and potential penalties and all factors that a bail judge would pursue to the bail statute, that would be appropriate and within their judicial discretion. Would the Commonwealth object to that? Likely, but that would be within their discretion.
So you're saying that you just can't, the judge just does not have the discretion to deliver to the custody of DYS, so a 18-year-old who's charged with murder.
Yes, under Section 68, the statute does not grant the judge any authority or discretion. It explicitly says if a juvenile is charged with murder, they must be committed to the custody of the sheriff if they are unable to post bail. So this judge decided to hold the defendant without bail. If she wanted to impose a cash bail, that would have been within her discretion. But where the defendant is unable to post that bail, he is committed to the custody of the sheriff and shall remain in the custody of the sheriff pending trial. And if there are no further questions, I would rest on my brief as well as the amicus letter submitted by DYS in this matter.